All right, we're going to go ahead and start, and I want to thank everybody for joining us on this wonderful rainy Friday afternoon. And today we're going to be talking about our 9-step guide to protecting your children. And really this webinar is designed for parents or even grandparents, really, but people with minor children in your family. It could be because you're a parent of minor children, or maybe because you're a grandparent and you want the information to tell your children because they've got minor children. But the entire purpose of this webinar is to prepare parents and grandparents with young kids with the 9 steps that they need to do today in order to protect those children from a family emergency. And so let's get into a little bit about myself. I'm James Long. I'm a estate planning attorney. I've been doing estate planning for 10 years now. I'm married. I've got 2 kids and a dog. I also have a cat. The cat's not pictured because the cat's kind of surly and is a little bit mean, but kind of like a love-hate. Sometimes he loves you, sometimes he hates you. So cat's not pictured, but you know, we've got the 2 boys and a dog, and there's my lovely wife. And like I said, I've been doing this 10 years as an estate planner. And last year in May, I started my own firm called Regnum Legacy. And one of the reasons why I started Regnum Legacy was because I became a father, really. And once you become a father, once you become a parent, as all parents know, things change. The way you engage with the world changes. And certainly the way I engaged with my estate planning clients, and certainly the way I thought about estate planning law changed fundamentally as I became a father. Before becoming a father, I was a seminarian, so I was studying to be a different kind of father in the Catholic Church. I was an expert for the Vatican at the United Nations. Went to law school at the University of St. Thomas, and like I said, for 10 years I've been doing legal work as an estate planning attorney and litigator. And in May, I gave all that up so I can focus exclusively on estate planning for families, and particularly estate planning in a way that is really geared towards becoming a truly trusted advisor for families just like yourself. And so I started Regnum Legacy, and Regnum Legacy is I say it's a Catholic law firm. It's not necessarily a Catholic law firm because we don't only represent Catholics, but the name Regnum means kingdom in Latin. It's a holdover from my old seminary days when Latin was sort of grilled into us. And it means kingdom. And so the idea is that I want a firm that's continually looking forward towards one, the afterlife, the things that we know that are to come, but also in a way that's not fearful. That's not going to be apprehensive, because when you're talking about death, when you're talking about dying, a lot of people, you yourselves included, might be a little bit apprehensive, might be a little bit scared. And one of the things I believe that estate planning does is really help you sort through some of those issues. And some of the topics we're going to be talking about today are going to be a little heavy, because I'm going to ask you to think about what would happen if you were to pass on, or if you were to get injured or incapacitated, and no one was able to take care of your children. And that's like sort of a scenario that parents don't really want to think about. But Regnum Legacy itself, my law firm, is really designed for families just like yourself, because at the end of the day, we want you to be our lifetime client. We want you to be part of our family. And we've got a whole wall, not here, but pretend this is our conference room. Our whole wall in our conference room's got photos of all our clients, because we really care for them like family, and we want you to become part of our family. So I started Regnum Legacy with the idea of truly creating a family environment to focus on really what matters most in the kingdom of all the things that matter. If you want to go back to Regnum Legacy, the kingdom of all things that matter, it really comes down to our loved ones, who we love and what we love. And that's what estate planning is all about. People have started taking notice, even though we've been open for just about under a year. Acquisition International has named us in 2020 the most innovative estate planning law firm, and Lawyers of Distinction recognize us for excellence in estate planning law. So things are going, we're doing something right here. We're doing something right. Not to toot my own horn, but I'll just toot my own horn. Okay. So I want you guys to think about, we're going to get into now talking about you and your family. And one of the things I'd like to invite you to think about is, if something happened to you today, if you and your wife, or you and your husband, or your spouse or significant other, or whoever it might be in your life, were out on a date and you weren't able to come home, either because you were in an accident, you became incapacitated, something happened, some emergency happened, who would care for your children? Now, I'm going to tell you that this is actually a thought exercise I had to go through myself, which is one of the sort of fundamental changes in my own estate planning journey. I was on a date with my wife, and I had that thought. We had left our kids with a babysitter for the first time. Usually we leave them with family, but this was the first time we left them with a, teenage babysitter. And she's a great person, but on that date, I kept thinking, the estate planner in me was thinking, what would happen if we died? We've named long-term guardians for our children, but the reality hit me that the gal we left our kids with wouldn't know what to do. She's at the time she was 15. I think now she's 18, but at the time she's 15, the police would come. They would try to notify next of kin. They wouldn't know who she was. She's not a relative. She's under 18, and she wouldn't know who to call or what to call, because she has our numbers. And of course, if there was an emergency, those numbers wouldn't necessarily be working. So the realization hit me that my kids would be taken into the custody of the state, and that just did not sit well with me at all. And so I had to go through this process of what the heck would happen to my kids if something happened to me. And the realization, at least on that date, was I didn't like what the answer was. And so I start this webinar with that question to you. What would happen to your children, or who would care for your children if the worst happened, if there was an emergency? Now, let me tell you that there is a plan, right? Even if you don't have an estate plan, there is a plan. The state has a way to decide the answer to that question, and you might not like it. So let's go to the next slide, and we'll see. Let's see here. There we go. Okay. So there's two things you need to think about, or two things the state kind of thinks about when an emergency happens. The first thing is, who in the short term immediately can care for the children? And if you don't have an estate plan, if you don't have a plan in place, that's going to be the babysitter, right? It's going to be maybe you have no plan at all, and so the police have to decide on the fly what happens. And if there is no plan, and if that babysitter is not family or is under 18 years old and doesn't have legal authority to take the children, then the police are going to take them into the CPS local office, and they'll spend the night in a foster home. And I'd like to just sit with that for a second. Your children will have been told that they've lost their parents, however they get told, mommy and daddy aren't coming home, mommy and daddy went to heaven, whatever it might be, but they're going to hear that for the first time at the kitchen table of a stranger, some foster home somewhere in California. Some stranger is going to tell your children what happened. And what really changed my thinking on this as a father was, that's unacceptable to me. And I'm sure as you're listening to this, that's unacceptable to you. But that's the reality. If you don't have an actual plan in place, or if the babysitter you leave them with is not family, or if the babysitter you leave them with has no clue who to call, your kids are going to get a free ride to a foster home, and that's where they're going to spend the first night without you, at some stranger's house. All right, long term now. After that initial sort of notification period where the police come and they notify the family that there's been an emergency, mom and dad are in the hospital, whatever it might be. at some point, the court is going to need to appoint a guardian for the children. When you have a minor child, that minor child needs to be cared for by a guardian. That's the name of the person who cares for a child. It's called a guardian. And parents are the de facto guardians of their children. But if the parents aren't able, either because they have passed on or because they become incapacitated, if they're not able to be the guardians of their children, the court appoints a guardian. And there's a plan. The plan is a judge decides based on sort of very structured criteria of who gets to be the guardian of your child or your children. And mostly what the courts are looking for is stability. So they're going to look for a family member. They're going to look for a family member who's stable. So do they have a good job? Are they themselves married? And they're going to look for a family member that would represent the least disruption to the child. Because, if all things are being equal and one family member is 20 minutes away and another family member lives in a different state, the court's just going to appoint the family member that lives closest, because in the court's eyes, staying in the same state is less traumatic for the children than packing up and moving to a different state. So, you can kind of do your own thought experiment of the family members who live closest to you and think, are they the ones that I would want my children to be with for the remainder of their sort of adolescence until they're 18 years old? And if the answer to that is no, I guarantee you're not going to like the state's plan for you, because that's probably exactly what the state's plan is going to be. Now, there was a really tragic case that occurred about 5 years ago. A family in California was going on vacation. They piled into the family van. They headed out. They were in a car accident. Mom and dad died, but the children survived. And the issue in that case was who would care for the children. And the family themselves were real devout Christians. They had strong values. They kind of had a particular way that they wanted their children raised. And I suppose luckily for them, a majority of their family members thought similarly to them. That is, they had a number of family members scattered throughout the state of California and in different states that had similar beliefs as they did. Unfortunately, the first family member they could find was a member of the family in San Diego who did not really believe what the mom and dad believed. She was an atheist. And I'm not saying that there's anything wrong with being an atheist or anything like that. But for this particular family, and in this particular case, it was relevant, because what happened was the court appointed the aunt in San Diego to be the guardian of the children. And what happened was the rest of the family members sued and petitioned the court to remove the children from the custody of the aunt, because what the claim was that the aunt didn't represent the values of the parents. And I hear this all the time in my practice when it comes to guardianship or maybe the way a trust is being divided or something. They'll say, this is the last person on earth that mom and dad would have wanted to raise their kids, or this is the last person on earth they would have wanted the estate to go to because of mom and dad's values. And unfortunately for the courts, they really don't care about those kinds of things. They don't care about enforcing the values of mom and dad. What they care about is objective criteria like, is the aunt stable? Does she have a good job? Is the aunt, on drugs or not on drugs? Those kinds of things. And does the aunt live close enough to the parents so that the children wouldn't have to be that disrupted in their daily life? And in that case, the answer was yes. And so the aunt prevailed. But for those children who lost their parents, the rest of their family were fighting over them for, I believe the court battle took 2.5 years or so. And for 2.5 years, those children were in the middle of a court battle between the family fighting over who gets to have custody of them. And so not only did they lose their parents, but they also had to endure a court battle and family members fighting over who gets to raise them. And so there is a better way than this. There is a better way to plan for this eventuality so that as traumatic as, your death would be to your children, as the traumatic as my death would be to my children, I can take steps now to make sure that that traumatic experience isn't made all the worse based on my lack of preparation. And so that's what we're talking about here today. And that's what we're going to show you the steps you need to take to soften that blow, to make it as minimally traumatic as possible if the worst should happen. Okay, so 9 steps. Now we've got 9 steps to protect your children, and we're going to go over them now. Step 1, let's do it. Step 1, first and foremost, and we include this in almost every estate plan we do here at Regnum Legacy, you have to have a long-term guardian picked. And I always tell clients, when you're picking a long-term guardian, you need to use a non-emotional approach. Far too often, I get clients or I hear people who say, well, I want my mom and dad to be the guardian of my children because they just love grandma and grandpa so much. Or I don't want to offend my mom and dad and make them think that they're not worthy to raise my kids. If that's what you're thinking about when it comes to your children and who should be guardian of your children, that's a very emotional reaction. And so what I encourage clients to do is step back and use a non-emotional approach to decide who should be the long-term guardian of your children. And there's a 3-step process. And here's the steps. First, you really need to get clear about what your values are. Sit down with your partner, your wife, your spouse, your husband, whoever that might be, and really get clear about what your values are as a parent. My wife Vanessa and I have done this, and we kind of, thought about the key values that we hold ourselves. And they're informed by faith. This is just personally for me, informed by faith. We're Catholic, but also informed by sort of parenting philosophy. We have a particular parenting philosophy that we raise our kids by, and that my wife and I are on the same page with. And, more or less, to some degree, I might do something that my wife disagrees with, and my wife does things that I disagree with. But for the most part, we're on the same page philosophically with how the kids should be raised, how they should be disciplined, what standards they're held to, all sorts of things like that. And so when you're thinking about your values, think about your religious values, your parenting philosophy, how you want your kids disciplined, what standards you want them held to, and, basic things like that, parenting philosophy, okay? Get clear about what that is for you first. Second, and I need to move. Let's see if I can move. Where can I move so you can see this? I'm going to move me here. There we go. Okay. Second, you need to think about the people in your life that emulate those values. Who shares those values? Your religious beliefs, your parenting philosophy, your general philosophy of life. And of those people, who of those people are closest to your children, both in relationship and proximity, right? Because, for example, my parents live in Colorado, so they're not close in proximity in location, but they might be close in relationship to my children. So you need to think about, okay, who has the values that you have, who shares your values, and who's close to my children, both relationship-wise and in proximity, okay? All right. The third thing you need to think about is all the people who aren't sharing your philosophy. Who are the opposite of those people? Because you'll see in the later steps, one of the final steps is naming who you don't want to be your child's long-term guardian, because that's almost as important as naming who you do want. So think about those 3 things, and it's a non-emotional approach, because you're not thinking about, oh, well, my mom and dad help me raise the kids, and so I really feel obligated. No, it's literally about who shares the values, who's closest, and who has the best relationship with the kids, and who is, going to be able to step in quickly and be, provide the smallest transition for the child. Okay. This is just a personal note from how me and my wife did it. And you don't have to do this as well, but I always tell clients this. One of the things that my wife and I talked about or thought about was not just who was close to our children, but what types of relationships do you want your children to have after you're gone. So, for example, my children are close with my wife's parents, and my wife's parents babysit a lot because they live about 30 minutes away from us. They love them. My kids love my parents, but we strategically chose not to name them, my parents or her parents, as guardians, because going forward, we thought it would be valuable if our parents could keep the grandparents. In other words, we thought it would be a value for us and for our children if they had grandparents. We didn't want grandparents to become parents. We wanted them to have that grandparent relationship. So we've actually named one of Vanessa's brother as our kid's long-term guardian, because he lives close, they know him and things like that. And my parents and her parents can still be grandma and grandpa, can still spoil the heck out of our kids, and they don't have to be mom and dad. They can always be the person they go to be grandma and grandpa. That was important to us. It might be important to you, but that's the way you should think about it in a non-emotional kind of way. Okay, so that's the 3-step process. Let's go next slide. Boom. Okay, step 2, you need to legally document your choice. All right, what does this mean? In California, what it means is you need to have now I'm blocking this part. Let's put me here. Okay. No, let's put me here. There we go. Okay. In California, that means you have a nomination, a guardian nominee, basically. And what that tells the court is this person who we nominated, I've nominated this person to be the guardian of my child. That person is the person the court will appoint. Okay. There's nothing you can do now to skip the court process, but you can select who you want the court to choose today. So you can nominate a long-term guardian, and importantly, you can nominate who you don't want the court to appoint. If there's someone you know absolutely should not be raising your kids because maybe they've got a drug addiction, maybe they just don't share your values, or some other reason, put them in. That way, if there's ever any challenge, the court can look and say, I don't care about your challenge. I don't care about all the reasons you want to raise the kids. They said no, I'm saying no. Okay? And let me just sort of peel the curtain back a little bit about sort of the realities of what happens to your estate after you pass, because this will help when you think about who you don't want to be guardians of your children. If you pass on with an estate that has, let's just say, substantial assets, you've got a house, maybe you've got a large life insurance policy, and there's money to be had. Family members tend to know that kind of stuff. And you can see family members step out of the woodwork with ulterior motives, because typically, unless you have a robust estate plan that kind of really tracks things well, typically whoever's the guardian of your children is also going to control like the inheritance. They're going to control the money until the kids turn 18. So if you have a substantial estate, one of the ways to get your hands on that money is to become the guardian of the child, so that you can control some of the money for a little bit. And so you may think like, oh, well, my brother or my sister or my cousin would never, want to raise my kids. But if there was, $1 million life insurance policy, your family's got a million reasons to want guardianship of your children because they get to control the purse strings. Now, there's other ways you can, plan for that in your estate to kind of guide where that money goes and how it's operated, so you reduce those risks. But as it relates to guardian nominations, you should think about who you don't want on there and name them so that they're discouraged from sort of petitioning the court in case they have ulterior motives. And everybody knows, like, if you have that person in your family, you know that person, right? Right? You just know that person. I've had many clients over the years say, oh, this person's a money grubber, or this person's just sue happy. You know the type of people, and those are the people you should name, like, I don't want this person, because it can really avoid a lot of hassles. Okay. So step 2, you got to document your choice. Next, step 3, you need to think about short-term guardians. Remember in my story about the family who was on vacation, the family who was on vacation, immediately there was the police had to pick where where the kids were going to go. And in my analogy of my kids with the teenage babysitter, the babysitter wouldn't know where to go or who to call. And so one of the things I started doing or started recommending was you need to name a short-term guardian. And that's a person that the police could call. It could be a family member. It could be a close friend. It could be a neighbor, someone you trust that's within 20 minutes of your house, right? And in California, that could be a mile. That could be 10 miles, right? Depending on traffic, right? It's got to be someone who can get to the house quick so that if there was an emergency, the babysitter or the police or whoever's with your children can say, hey, there's been an emergency. You need to get down here and take the kids. Because if you've named a long-term guardian and they live in another state, it's going to take them a little bit of time to book a flight, get down here, be able to collect the kids, make arrangements, all sorts of things. And so if you have a short-term guardian named, the police know that this person has authority to take your kids in the short term while the long-term guardian is sort of getting prepared. So think about someone, family, friends, and this is where, for example, we've identified my wife's parents as a short-term guardian. My wife's sister is a short-term guardian. So these are people that can be called, that can get there and can basically take our kids in an emergency while the long-term guardian is, driving up from Costa Mesa somewhere, right? Stuck in traffic on the 55. So we've kind of named that. And that's what you should be thinking about at step 3. Step 4, again, legally document your choice for the short-term guardian. Now, just like the long-term guardian, you need to legally document this so the police know, yeah, this is legit. This person has legit authority. Unlike the long-term guardian, however, the short-term guardian is not appointed by a court. This isn't going to be something that's in front of the court. It's just a legal document that you would get notarized that basically says this person has authority to take my kids to their home or stay with my kids or whatever language you prefer for a short period of time. So that way they don't go into the custody of Child Protective Services. All right. Step 5. And this is a step that a lot of parents skip. You need to give your short-term and long-term guardians instructions. They need to have the legal documentation. They need to have instructions so that they know what to do in an emergency. So at a bare minimum, they should have a copy of the nomination so that at least they could present their credentials to the police if they needed to. But more importantly, what we're thinking about here is sort of basic instructions about what the heck to do, because at that moment when there's an emergency, they're not going to remember like, oh yeah, I attended this webinar at Regnum Legacy and I heard all about all the things I need to do. No, they're going to be struck with grief. They're not going to remember. And so if they've got a printed sort of instruction book, right, this is what to do, this is how you have to do it, it's going to cut through some of that, reduce mistakes, but it's going to cut through some of that stress. And this is something that we offer as part of our child's protection plan at our firm. Other firms might do it differently, but at our firm, certainly we offer a child's protection plan that covers all of these steps. Step 6, and let me change my face again so that you guys can read this. Here we go. Let's go to the top. Okay, step 6. Just like you would with your guardians, you want to give all of the caregivers and schools instructions on who to call. What does this mean? Babysitters, your daycare center, your kids softball coach, or whatever it might be. They need to have instructions about who to call in the event of an emergency so that wherever your kids are, if they're in school, if they're at softball practice, if they're in daycare, if they're with your parent, if they're with a teenage babysitter, you've got sort of a form instruction sheet about these are our emergency contacts, and these are the short-term and long-term guardians that need to be called who can take the kids. Because, if your kid's at softball practice, the police aren't going to let the coach just take the kids. The police are going to have to take them somewhere. But if the coach knows, oh, wait, I know who to call. We're calling Aunt so-and-so, and Aunt so-and-so can get down there within 10 minutes, it's going to make things a lot less stressful for, well, one, your children, but a lot less traumatic because they're not going to have to ride in the back of a police car while they go to a foster home in the meantime. So really sort of leave instructions. The other thing that we do is we give our families an emergency ID card that goes in your wallet. Now, EMTs and paramedics and police are trained to go through your wallet if maybe you've had a heart attack, maybe you're incapacitated, maybe you're in a car accident, whatever it might be. But emergency responders go through your wallet, not just to check who you are, but they go through your wallet to see, is there any instruction, right? Is there any guidance for what care choices they want? Usually, they might be looking for, if you're a Jehovah's Witness, you might have a card in your wallet that says, I don't want blood transfusions or something like this. Well, we provide a similar kind of card that says, hey, I have minor children at home, and if there's an emergency, call these people. That way, the authorities know, hey, you've got minor kids that need to be notified, and someone needs to be called to go over there and get them. And this is a crucial step in sort of coordinating these things. Okay. Let's see. Step 7. You want to tell your long-term guardians what to do if called upon, and where to find your long-term guardianship documents. Now, they should all have copies of the long-term guardianship document, but the originals, they need to be told where those originals are so they can be presented to the court. And so that's a step that I know a lot of people miss, because I get a lot of calls saying, hey, so-and-so just died. I know they had a trust. I have no clue where it's at. And, having these documents and paying a lawyer or going on LegalZoom or something to get these documents in place does no good unless people afterwards know where to find them. So make sure you tell people where to find them. And the second thing that you ought to be thinking about is give instructions for your long-term guardians about how you want your kids raised. And this goes back to thinking about why you named that person in the first place. You thought about your values. You thought about how this person matched your values. And so you should be giving an instruction like, hey, I chose you because you really share my value, and I want you to keep doing that. I want my kids to keep going to softball practice, and, or we have a family tradition of, wearing Christmas pajamas every Christmas Eve. And if you can, please keep those traditions alive, so that as they go on and start taking care of your kids will feel a little bit more like mom and dad are still there, because the traditions and the philosophies and the way that they were raised up until that point can sort of remain in a continuous or continuous stream. So you want to leave those instructions for your long-term care guardians. Now, part of our estate planning process when we do a kids protection plan is to develop that story for you, to document those kinds of things. And another thing that we do is we do more of like legacy planning as well, where you can leave like a legacy video for your family to say, here's what our values are, here's what our beliefs are, here's what our history is, so that your kids and your family members can remember that and can honor that. And so there's ways you can keep that as part of your estate planning and engage in it. If you have the right kind of estate planning firm behind you, like Regnum Legacy, or there's others that do this as well. All right. Step 8. We've mentioned this before. You have to exclude people you don't want to be in charge. A lot of litigation. Speaking as a former litigation attorney for the last 9 years, I was doing estate planning and litigation. And as a former litigation attorney, I can tell you a lot of litigation can be solved if the person proactively took steps to avoid it. Everyone knows that they have that family member. Maybe you don't have that family member in your life, but everyone knows if you have that family member, right? So hear what I'm saying and not what I am not saying. I'm not saying that everyone needs to exclude someone, okay? But if you have that person in your life, and if you're listening to this and you know it, right? You know it if you have it, right? You need to exclude them. You really need to exclude them, and you cannot be worried about their feelings. You cannot be worried about what emotions they might be going through if they knew they were excluded. You really need to think about what's best for your children and what's going to be least traumatic. And frankly, a prolonged legal battle about who should be guardian of the kids is the thing that they need the least in a family emergency situation. So think about that and really take the emotions out of it. And there's ways we could draft it to make it a little less harsh. You don't have to say like, this person's an awful person and I hate them and I don't want them in my life. Although you can say that if you want, but you don't have to. You can make it a little bit nicer and soften the blow. So there's ways to kind of build the emotional side into it, but take the emotions out of it. Think about who you don't want and then name them. Name the people you don't want. Finally, step 9. All right. This is going to be one that, we really can't help with, but it's something that you need, and we can certainly refer you to people, but you need to provide enough financial resources through, term life insurance or whole life insurance or savings or some sort of estate vehicle, retirement accounts, whatever, so that your kids can sort of be financially secure. Moreover, you need to have those things in a living trust, because one of the ways that you can make things as least traumatic as possible for your children like in the event of emergency or in the event of your death is to set up a living trust that has enough assets, maybe funded by insurance or your retirement accounts or your savings or something, that has enough assets that can sort of be there for them at the major events in their life, right? Because they'll be with the long-term guardian you name. But if you have a trust, you can say to the long-term guardian, hey, I've got this money set aside, and on their 18th birthday, you use this money to buy them a car. And on their 21st birthday, you use this money to buy him a drink. I want to buy my son his first drink when he's 21, and I've got $20 reserved just for that. And I want my kid to know that this $20 is from dad, right? That's the kind of thing you can do. You can be with them every step of the way. I want money set aside for my daughter when she's getting married because I want to buy her wedding dress. And so this $3,000, that's reserved for that. And I want her to know that dad bought that. I'm kind of tearing up just thinking about it, because as a parent, you want to be there for those moments, but none of those moments are guaranteed. And if you have a plan that works, and if you have a plan that's thoughtful, you could be there every step of the way, even if you're gone. Okay, I'll get off my soapbox. The dad in me is coming out, and I need to be Lawyer James for a second. But the upshot is, right, think about those types of financial resources and really either get a kids protection plan with us. There's other resources you can find to do these kinds of things. But if you really want to be there for your kids throughout their life, the vehicle you need to do that is a living trust. Okay, so step 9 is get a living trust. And I know it's kind of, maybe, self-aggrandizing or whatever to say like, hey, I'm a living trust attorney. Of course, I'm going to recommend a living trust, but it just makes sense if your goal is to be with your kids every step of the way, because alternatively they'll get everything at 18. And if you're fine with that, then you're fine with that. But if you want a more structured kind of way to go about it, the only way to do that is a living trust. Okay. All right. So what can you do today? To create the right plan, make sure you have the right plan, and what should it cost? All right. Here's your options, basically. Your option is you could do it yourself. There's plenty of resources out there, guys, like Rocket Lawyer and LegalZoom and all sorts of places where you can Google right now, California long-term guardianship nomination, and I'm sure you'll get a bunch of PDFs that'll spit out that you could fill in yourself, right? You could do it yourself. You could also work with a lawyer. And if you want to work with a lawyer, you need to know that not all lawyers are the same, okay? And not all plans are the same, all right? And what do I mean by that? Okay. There are 2 real ways to think about estate planning when you're working with a lawyer. And this is kind of the way my mindset shifted as a lawyer, was in this way. See, I used to think about being an estate planning lawyer is I'm going to provide a bunch of documents, right? I'm like an upgrade from LegalZoom, where I'm a human that produces documents. And that's the wrong way to think about it. Because if that's all you want, then go to LegalZoom, right? If all you want is some medicine, go to a pharmacy. But if what you want is a diagnosis, if what you want is to know for sure what you need and get a plan in place and to really strategize, then you need to go see, a doctor. You need to go see a lawyer. And you need to see an estate planning lawyer that does more than just prepare documents, because not all estate planning lawyers are the same. There's an estate planning lawyer just down the street that'll do everything that I do. I'll at least give you a set of documents that I do for $1,000 cheaper than I charge. But here's what they don't do. They don't help you protect your family, because they're not thinking about the other things. They're not thinking about short-term guardians. They're not thinking about your values. They're not thinking about instruction manuals. They're not thinking about the effect that this plan will have on your kids. And the reason you want a lawyer to do that is because as a parent, you want the most protective. You want the best. I want to say the best, but at the end of the day, your estate plan is only as good as the thought you put into it. So you can have one document that has the same words on it and another document that has the exact same words on it, and one could be better than the other. And the difference is the thought you put into it, right? So when you're thinking about a lawyer, you want to go to an estate planning lawyer, right? You don't want to go to an estate planning document preparer. You want to go to an estate planning lawyer. You want someone who's going to be a partner with you to sit down and plan through and think through these things and come up with strategies to really make sure that you're there for your children every step of the way. And that's kind of what we do here at Regnum Legacy. That's the type of lawyer we are. And if that's the type of lawyer you want, we're the type of lawyer that you need. Okay. So would you benefit from working with a lawyer? Well, if you own more than just personal belongings, right? If you're sitting there and you're thinking, geez, I don't know, should I go to LegalZoom? Should I not? Should I call James? Should I not? What should I do? Well, if you own more than just your personal belongings, right? So if you own a home, if you have, a retirement account, if you've got saving, large assets that are like life insurance policies and things like that, that could go to your kids, or more importantly, that could be siphoned away by an unscrupulous guardian, you might want to work with a lawyer. If you want to ensure that the people you love stay out of court and stay out of conflict, you want to make sure that the conflict risk is minimized, that your family has to spend as little time in court as possible or no time in court. Then you want to work with an estate planning lawyer who's geared towards and thinking about preventing that. All right. If what you have or what you want is something more protective than just a long-term guardianship, if you have minor kids and what you want is something more protective than a long-term guardianship, if you think, oh, I need a short-term guardian and I want the emergency cards, I want to make sure that my guardians are prepared to know exactly how to raise my kids, and I want to make sure my kids can remember all my values and my history and they remember me and all sorts of things, you have to work with a lawyer who is equipped to do that and who's experienced in doing that, because LegalZoom's not going to do that for you. The discount lawyer down the street's not going to do that for you, because what they're going to give you is a stack of documents and call it a day. They're going to mark you off a list and you're done. But if you want something more protective, you've got to work with an estate planning lawyer who is experienced and geared towards doing that. All right. And the final thing, and this is the most important, if you want to guarantee that your plan will work when your family needs it most, you've got to work with a lawyer, because like I said, you could have the same documents with the same words on it and one's going to work and one's not. The only difference is I've been doing this 10 years and I know when that document is not going to work. I know when this document is going to work. And I know if this document's not going to work, this is the way you can make it better or fix it or get a document or a plan that's going to work better. LegalZoom doesn't do that. Other things don't do that. You need to, have the benefit and counsel and advice from an experienced lawyer who's able to give that to you. All right. Here's the big thing to consider when you're thinking about, okay, LegalZoom or cheap lawyer down the street versus some other lawyer, right? And let me move my head. I'm going to make me smaller. There we go. Okay, so estate planning and this type of planning that we've been talking about, this 9-step plan, what you're really planning for, I know in your mind, the triggering event is death, right? Your death or your incapacity. But a lot of people, like the LegalZooms of the world and a lot of the sort of cheaper lawyers out there, what they're really planning for or what they're really geared towards is planning for death. They're a death planning attorney. That means they want to give you the documents you need to, every document you need at the time of your death. Those documents might help you avoid probate. They might protect your children, but you don't really know because it's just a document. It's not an actual plan. Those types of lawyers, those types of experiences don't have any ongoing legal guidance. They don't adequately protect your children. And it really only focuses on what money do you have? Do you have a house or not? Do you have over $166,000 in assets or not? They don't really focus on what truly matters, at least as it relates to raising kids and protecting children, which is your values, your family history, your stories, and ways that you can be there for your family at the most critical and important parts of their life. There's another type of planning, and I want to call it like true estate planning, or if you want to look at it, planning for life. It seems odd because estate planning and the work I do is every document is triggered on the incapacity or death of the client. But what you're really doing is you're preparing for life. You're preparing for life because you're looking at the life you have and the life you want to have and preparing for the moment, okay, when I'm not around, what life do I want my kids to have? What quality of life do I want them to have? What experiences do I want them to have? And that type of life planning is fundamentally different than just getting a stack of documents. All right, what does this mean? It means that all the fees are flat fees. You get to choose the fee. You get to choose exactly, your fee structure based on what works best for your family. It means that what you prepare for, the plan that is set in place, really keeps your family and your money out of court, and it keeps it out of the hands of the state, keeps your kids out of the hands of the state. It means that your kids are completely protected, both in the immediate term, the short term, and the long term. Not just who gets to raise them, but they're also protected in a financial sense, either through asset protection planning, structured trust development, or you've reserved money aside and sort of earmarked funds for those major moments in their life, high school graduations, buying your son his first beer, right? Buying your daughter a wedding dress or a prom dress or whatever it might be. You can think about those kinds of things and earmark that. And when you're really planning for life, that's what that looks like. And when you're working with an attorney that does that, you've made the right decisions. You know that your plan is going to work. It's going to be protected from outsiders. And more importantly, and I'm speaking for my firm now, you know that you're going to have sort of an attorney, your family attorney in your back pocket, no matter what, right? You've got a lifetime guidance and protection. Because here's what we do for all of our clients. Every client we represent, we follow up with every 3 years just to check in. Right? Kind of like going to the dentist. You get that card in the mail. Dentist says every 6 months, time for a checkup. Well, every 3 years, we call up our clients and say, hey, how are things going? What's going on? I know we named, Uncle so-and-so as the guardian of your daughter. Is that still working out? Do you want to change things? I know we set up this trust to be, a particular way. Have things changed so that maybe we want to think about an alternative way to plan. And that way you're assured that your plan is working throughout your life. You're assured that, hey, I've got a trusted advisor and a trusted confidant for my family in my back pocket, a phone call away. That's the difference in working with an attorney who's just preparing a set of documents and an estate planning attorney like my firm, Regnum Legacy, when they're really planning and preparing you for a full life and preparing your children for a full life and lives to come, grandchildren, and all sorts of things that we can plan for in estate planning. All right, next slide here. All right, so I'm going to open it up to questions. If anybody's got any questions, I set the chat, okay, to private. I should have said this at the beginning. The chat has been set to private. So if you type in a question, there's no, what do you want to call it? Nobody else can see it except me. That way, if you've got sensitive sort of like questions involving real life legal issues that maybe you want protected or want to maintain privacy, I'm going to be the only one that sees it. So the chat's been set to private. If you got any of those questions, email it to me. My assistant, Rachel, who you can see here in this picture, is moderating this, and she will tell me, James, you got a question. And if not, then that's fine. But if you don't want to go through the chat, you can contact us. There's our phone number. There's my email address. That's my personal email address. Send me an email. Ask me a question. I'll shoot you back a response. You can give us a call, and we'll set you up for a consultation. There's no charge for the consultation. You can just ask the question, because I really want to make sure you're getting the legal advice and the sort of the legal counsel that you need at a time when you need it most. And so there's no sort of payment bar to, get some, a free consultation with me. Now, if we decide like, hey, you need an estate plan, we can talk about the fees at that time. But other than that, there's no sort of charge for an initial consultation. And what do we got next? Thank you, everyone. Thank you. And we have one offer. Let me pull up this offer here. I don't think I put it on here. Oops, I didn't download it. Sorry. We have a February offer. And the offer is this. So if you schedule a family legacy meeting, and this is how we do it at my firm, when you want to engage in estate planning, you think you might need maybe you think you need an estate planning living trust, or you need a child's protection plan or something, you're going to sit down with me for a strategy session. We call it a family legacy meeting. Usually costs $500, but if you've attended this webinar, or maybe you're watching it a replay, you can call my office and say, hey, I attended this webinar, or I saw this replay on YouTube, or whatever it might be. And I want that discount, because it usually costs $500. But if you're listening to this or you've watched it, we'll waive that $500 fee, but you got to do some homework. You've got to turn in a worksheet that's going to kind of give me some information about your family. And you got to show up for a family legacy meeting in which we kind of engage and strategize about what your family situation is, what your concerns are, what your goals are. And then we can kind of go over like, all right, here's the plan. Here's what I think would work for you based on what you've told me. Here's how much it costs. And whether you go forward at that point or not, that's up to you. There's no obligation. But if you schedule that in February, that's February 2021, we'll give you a $75 Amazon gift card. In addition to getting that legacy meeting, that $500 fee waived. So go ahead and book that now. You can give us a call. And let me see if we have a chat thing. I don't see any chats. Everybody's shy today, and that's okay. That's okay. That's perfectly fine. But I know you've got the questions, and if you've got any burning questions or desires, shoot me an email, give us a call. I'd be happy to counsel you, whether you become a client or not. I really don't want you to worry about having to come up with $350 for a consultation or something. I've been doing this 10 years, and I certainly can give you any type of guidance. So we don't put any money bar for our consultations. Give us a call. We'll set you up with a consultation with me, and I can give you some more guidance. If you want something a little bit fuller to come up with, develop a strategy with, what kind of estate plan is right for you. Like I said, we have a family legacy meeting that usually costs $500, but we'll waive that if you just call in and let us know that, hey, I went to a webinar, or I saw this webinar, or whatever. All right. But unless there are any burning questions coming up, we'll call it a day. I want to thank you all for attending this webinar. Thank you for your attention. And really thank you for investing this time as a parent, or a grandparent, as the case may be, into learning better ways and best ways to protect your family. Because as a father, I can tell you, some of these strategies were foreign to me until I became a father. And once I became a father, I started to look for and try to find ways that I would protect my own children. And so at Regnum Legacy, that's kind of how I'm your lawyer. I give you the same kind of thought and attention that I give my own family, because I want you to take advantage of the same thoughts and attention that I give my own children and the same protections I give my own family. Because if I'm not doing that, I'm not really doing my job. And with that, we'll say bye, and we'll see you at the next webinar.